What if I told you the family immigration process you've depended on for years is about to change in a major way? Thousands of families across America are waking up to a new reality. Bringing loved ones to the United States just became a lot more complicated. In January 2026, the Trump administration announced major changes to I-130 family petition rules that could impact your ability to sponsor parents, siblings, spouses, and children. If you have a pending petition or you're planning to file one, the next few minutes could decide whether your family stays together or remains separated for years. Hello, everyone. You're watching US Updates Hub. I'm your host, bringing you the most important updates on American immigration, visas, and policy changes that can directly affect your future in the United States. Today, we're breaking down the latest announcement on family-based immigration and the I-130 petition process. These changes are expected to take effect in early 2026. And if you don't clearly understand what's happening, you could face serious delays, denials, or even long-term separation from your family members. Watch this video until the end, take notes, and please subscribe to US Updates Hub so you never miss an immigration update that could change your life. Let's start with what the I-130 petition is and why it matters so much. The I-130, officially called the Petition for Alien Relative, is the foundation of family-based immigration to the United States. This is the form U.S. citizens and lawful permanent residents file with USCIS to prove there's a qualifying relationship with a foreign family member. Once the I-130 is approved, it confirms the relationship is valid, and your relative can then move forward with an immigrant visa through consular processing, or, if eligible, adjust status inside the United States to become a permanent resident. The I-130 covers multiple family relationships, including immediate relatives like spouses, unmarried children under 21, and parents of U.S. citizens, along with preference categories such as siblings, married children, and adult children. For decades, family reunification has been a cornerstone of American immigration. Millions of immigrants have used the I-130 process to bring loved ones to the U.S. legally. But in January 2026, major policy changes were announced that are reshaping how these petitions are reviewed, processed, and approved. These are not small technical updates. These are major shifts that reflect a broader enforcement-focused approach and an effort to reduce overall immigration numbers, especially in family-based categories. First, there is a major increase in scrutiny and heavier documentation requirements for I-130 petitions. Under the new guidelines, USCIS is requiring petitioners to submit significantly more proof to establish the legitimacy of family relationships. In the past, basic documents like birth certificates, marriage certificates, and proof of the petitioner's U.S. citizenship or permanent residency were often enough for straightforward cases. Now, under what's being described as enhanced vetting, even routine I-130 petitions may be reviewed far more aggressively. USCIS may request extensive evidence of relationship history, stronger proof of financial interdependence for spousal cases, detailed affidavits from third parties, photos covering the full relationship timeline, and, in many situations, certified translations of foreign documents from approved translators. Practically speaking, filing an I-130 becomes more complicated and more expensive. Many people may feel they need an immigration attorney or qualified professional just to assemble the package properly. You may need paid translations. You may need affidavits from friends, relatives, and colleagues who can confirm your relationship. And even after submitting all of that, processing times may rise because officers will spend more time reviewing each petition. Cases that once took 6 to 12 months may now take 18 months or longer. And that's only the I-130 stage, not the entire immigration journey. Second, there are stricter financial requirements for sponsors. When you file an I-130, you're not only proving a relationship, you're also committing to financially support your relative so they don't become a public charge in the United States. This is typically done through Form I-864, the Affidavit of Support. Previously, the standard income requirement was commonly 125% of the federal poverty guidelines for your household size. If you didn't meet it, a joint sponsor was often an option. Now, financial standards are tightening. Proposals indicate the income threshold could increase to 150% or higher. Joint sponsors may be restricted, making it harder for families to qualify if the main sponsor doesn't meet the income level personally. Assets may also face heavier scrutiny, and assets may not be accepted to cover an income shortfall unless you can prove they're liquid and readily available. Here's what that means for real families. If you're a U.S. citizen sponsoring only a spouse, you might currently need around $28,000 per year depending on the guideline chart and the year. If the threshold moves to 150%, that could jump to roughly $33,000 or more. If you're sponsoring multiple relatives, like a spouse and parents, the required income rises quickly. For a household of 4, you could be looking at $50,000 or more annually. Many American families simply don't earn that, especially in lower-wage jobs. The result is that working-class and lower-middle-class sponsors may find it much harder to reunite with family through the family-based system. Third, there are expanded grounds for denial and increased use of requests for evidence, also known as RFEs. An RFE is a notice from USCIS requesting additional information or documentation before a final decision is made. The number of RFEs has been rising, and under the 2026 approach, USCIS officers may have broader discretion to question the bona fides of relationships and deny petitions based on concerns that can feel subjective, such as whether a marriage appears genuine, whether family ties seem strong enough, or whether the petitioner has demonstrated enough commitment to supporting the relative. The administration is also pushing USCIS to take a tougher approach on inconsistencies, even small ones. A minor date mistake, a different spelling of a name on documents, forgetting an old address, issues that might previously have been corrected easily, can now trigger an RFE or even a denial. The message many families are receiving is clear. The process is becoming more difficult, more expensive, and more stressful, and that may discourage people from applying at all. Fourth, family preference categories may face even more difficulty due to priority dates and visa bulletin retrogression. Family preference categories are limited by annual numerical caps, which creates backlogs, especially for countries with high demand like Mexico, the Philippines, India, and China. Your priority date is the day USCIS receives your I-130, and it determines your place in line. You can only move forward with consular processing or adjustment of status when your priority date becomes current under the monthly visa bulletin. Under the current direction, many people are seeing slower movement in priority dates. So even if your I-130 gets approved, your family member could still wait years longer before they can actually immigrate. In some sibling categories, waits already exceed 20 years for certain countries. And with slower movement, those waits could stretch to 25 or even 30 years. Fifth, there is increased scrutiny of adjustment of status applications, even for immediate relatives already inside the United States. Many people file I-130s for spouses or children who are already in America on tourist visas, student visas, or with complicated immigration histories. Historically, immediate relatives of U.S. citizens, spouses, parents, and unmarried children under 21, often had more flexibility to adjust status if they otherwise qualified, depending on the facts. Under the new approach, USCIS is taking a stricter view of overstays, unlawful presence, and suspected fraud. Even immediate relatives may face longer processing times, more interviews, more investigation, and a higher risk of denial. For example, if someone entered on a tourist visa and married a U.S. citizen shortly afterward, USCIS may suspect misrepresentation and investigate more aggressively. Officers may look closely for any gaps in documentation, minor violations, or anything they interpret as fraud. Now let's talk about how this affects specific family categories. If you're a U.S. citizen sponsoring a spouse, expect heavier evidence requirements to prove the marriage is real, more in-person interviews, and more detailed questioning about your relationship, daily life, finances, and future plans. They will be watching for inconsistencies. If you're a U.S. citizen sponsoring parents, you may face the same enhanced documentation and financial review. And any prior immigration issues your parents may have, previous overstays, unlawful presence, old denials, could be examined more aggressively. If you're a lawful permanent resident sponsoring a spouse or unmarried children, the process can be even harder because you're in preference categories with longer waits. And USCIS may also scrutinize whether you're maintaining your own permanent resident status properly. And for siblings of U.S. citizens, this category is already the slowest. There has also been discussion about eliminating it entirely. Even if that would require Congress and hasn't happened, the fact it's being discussed shows the direction policy is moving. So, what can you do right now to protect your family's immigration future? First, if you plan to file an I-130, file as soon as you reasonably can. Your priority date is locked the day you file, and every month you wait can add time to an already long process. Second, submit the most complete and well-organized petition package possible. Don't file only the bare minimum. Include strong evidence of your relationship, detailed personal statements, photos, communication records, and, where relevant, financial documents showing joint accounts, shared responsibilities, and genuine interdependence. Third, seriously consider hiring an experienced immigration attorney. With higher scrutiny, professional help can reduce mistakes, identify weak points before USCIS does, prepare you for interviews, and ensure RFEs are answered properly. Fourth, prepare financially. Review your income carefully. If you're close to the threshold, plan early. If a joint sponsor is still possible in your situation, line that up in advance. If you plan to use assets, be ready to prove they're liquid, accessible, and documented correctly. Fifth, be accurate and honest on every form. Under stricter review, false statements or major omissions can lead to denial and serious consequences. Even honest mistakes can cause delays, so triple-check every detail before you submit. Sixth, if you receive an RFE, respond fast and respond thoroughly. You may have only 30 to 60 days. Provide everything requested and address each concern directly. If you're unsure how to respond, get legal help immediately. It's also important to understand your options if your I-130 is denied. You may be able to appeal or file a motion to reopen or reconsider, but these steps are technical and time-sensitive. In some cases, it may be better to fix the issue and file a new petition instead of appealing. The right path depends on your exact situation, which is why legal advice matters. And most importantly, stay informed. Immigration policy can change quickly, and rumors can damage real cases. Follow reliable sources like US Updates Hub, where we explain what changes mean in practical terms. Don't rely on someone told me advice or unverified social media posts. If you filed your I-130 before these standards take effect, understand USCIS may still apply updated scrutiny to pending petitions. If you receive an RFE asking for more evidence, that may be the new approach showing up in your case, and you must respond strategically. Also remember, family-based immigration isn't the only option. Depending on your situation, you might explore employment-based routes, the diversity visa lottery, humanitarian pathways, or other lawful strategies. Every option has its own requirements, but it's worth knowing what's available. Let me warn you about common mistakes that have become even more expensive under tighter rules: rushing and submitting a weak petition, hiding or failing to disclose past immigration violations, failing to maintain legal status when required while a petition is pending, and not updating USCIS about address changes, causing you to miss critical notices. Overall, the direction we're seeing represents a major shift away from family reunification as the central principle. Whether you support it or not, understanding the direction matters because it helps you plan realistically. If this trend continues, expect more tightening, more enforcement, and more obstacles in family-based cases. I want to be honest, these changes can make family immigration much harder. Many families may face longer separation. Some petitions that would have been approved in the past may face denial now. Financial barriers may prevent some sponsors entirely. That's the reality many families are facing in 2026. But don't lose hope. Thousands of families still succeed every year, with careful preparation, strong evidence, patience, and the right legal guidance. Reunification is still possible. It may take more work, more documents, and more time, but it can be done. Here on US Updates Hub, we're committed to helping you understand these changes and make smarter decisions. We'll keep tracking policy updates, breaking down new announcements, and explaining what they mean for you. If this video helped you, hit the like button and share it with anyone going through the family immigration process. Subscribe to US Updates Hub and turn on notifications so you don't miss the next update, because policies can change fast, and staying informed is one of the strongest protections you have. Drop a comment with your questions or tell me what topic you want next. I read the comments, and your feedback helps me make content that addresses your real concerns. Remember, knowledge is power in immigration. The families who succeed are the ones who understand the rules. Prepare carefully and act strategically. If you're planning to sponsor a family member, start preparing now. Gather documents, review your finances, and if needed, consult an immigration attorney. The sooner you act, the better your chances. This is US Updates Hub, and I'll see you in the next video. Stay informed, stay prepared, and don't give up on bringing your family together. Take care.